Okay, thank you all again for joining us today. We are very fortunate to have the Honorable Maria Elena Cruz from Division One of the Arizona Court of Appeals, and also Professor Kristy Clairmont from the University of Arizona College of Law. I hear bear down is the thing to say. We're so grateful for these ladies to be here with us. Our very esteemed presenters will be speaking with us about what legal paraprofessionals can and cannot do under the rules, and also help us understand the ins and outs of working with them. Just a little housekeeping before I turn it over to Judge Cruz and Professor Clairmont. If you would, please make sure that your name and not your telephone number is on your Zoom sign-in. That is for CLE credit purposes. The CLE session is being recorded for future viewing, so we do ask that you please keep your microphones muted during the presentation. If you have questions during the presentation, if you would use the chat box here on Zoom to type those questions into the chat box so we don't interrupt the presentation. We'll hold those questions for the end, and we'll have an open Q&A session. During the open Q&A session, you'll be able to unmute yourself. But again, if you place questions into the chat, we'll capture those and cover them at the end. The materials for today's session are posted to ACBC's website as always, and they've been placed here in the chat box here on Zoom. If you've just joined and you don't see those materials, we'll add them there in just a minute so that you do get those. The PDFs in the chat box aren't always visible to everyone. If you're not able to see the PDF materials, please let us know. Either send us an email at admin@acbcforum.org or put your email address in the chat box here so that we can send those PDFs of the materials to you. That's very important because toward the end of today's session, we're going to post the CLE certificate for today into that Zoom chat. If you can't see the PDFs, you're not going to get the CLE certificate. So be sure to let us know if you're not able to see the PDF so that we're aware. And importantly, be sure to grab that CLE certificate when we post it in the chat. We will make a verbal announcement about that towards the end of the session. Thank you again, Judge Cruz and Professor Clairmont. I'll turn it over to you.
Hello, and thank you for having us. I'm Maria Elena Cruz, and as Crystal mentioned, I am a judge on Division One of the Court of Appeals. And so we are excited to speak with you about the legal paraprofessional certification, what it means, who are these folks, and what space are they operating in within our systems. We'll begin with a little bit of history, looking back to how it is that we got to where we are. But let me give Kristy the opportunity to introduce herself and then kind of set up for us what we're going to be going over.
Thank you, Judge Cruz. My name is Kristy Clairmont. I work at Arizona Law as a professor of practice and as a director in our career development office. I was also the program coordinator for the LP educational programs at Arizona Law. We're really happy to have all of you here with us today. This program is so important and such a groundbreaking moment in the practice of law, period. So although some of the information may not be pertinent to your day-to-day practice as a bankruptcy attorney, it is part of our duties as attorneys to stay up to date on changes that are happening with our legal profession. So I think that you will find today's information extremely pertinent, and we so appreciate you being here today. That said, today's agenda and this presentation is designed on purpose to kind of spur some discussion. So up front, we're going to load you with a little bit of information about the LP, and then we're going to segue into some scenarios. So with that in mind, I would like you all to if you're able to, with a show of hands or even the digital hand, if you have access to that on your Zoom functionality, I would like to kind of see how many of you before registering for this program had ever heard about legal paraprofessionals. If you could just kind of indicate that. Great. Okay. There's a few more of you than I even expected. So that's really good to see. This kind of helps us know. And for those of you that haven't, never fear. That's exactly why we're having this training. So with that, I always think it's best to start from the beginning. Judge Cruz is going to give us a quick historical background of how this program began.
Yes. Thank you, Kristy. So back in 2018, when Chief Justice Scott Bales was still a member of our Supreme Court, he recognized that the legal community was not serving the needs of consumers in our state. Low-income Americans in prior years have received no or inadequate legal help. And funding for legal services corporations was inadequate. One study showed that well over 100 million Americans were living with civil justice problems, many involving what the American Bar Association has termed basic human needs. And so merely assisting litigants to navigate the justice system alone by means such as navigators or document preparers was found to be insufficient to ensure that Arizonans had meaningful access to our courts to resolve their legal issues. And it was found, and I thought this was an interesting piece of data, that U.S. lawyers would have to increase their pro bono efforts to over 900 hours each to be able to provide some measure of assistance to all households with civil legal needs. So because of that sort of unmet need in the legal realm, the market, as you know, will find a way. And so there's a large market for legal services, technology-based artificial intelligence platforms, and they stepped in to serve clients. Online entities assisted customers and still do, informing businesses, registering trademarks, drafting wills, and other legal forms. But that comes with its own set of concerns and perils. And oftentimes it's not enough, because when people end up in court, there's a gap there, and the ability to represent yourself in front of a tribunal, especially when there's a lawyer on the other side, then becomes an issue. So there's this sort of space where there is need, but not enough lawyers serving. So even the Arizona Supreme Court, since 2003, has authorized certification of legal document preparers. The state bar has implemented the web-based Find a Lawyer program. And so there have been efforts to try to connect lawyers willing to do pro bono work at an affordable cost, but it still has not been enough. So Justice Bales decided to put together a task force on delivery of legal services to look at what recommendations could be made, innovative, completely outside the box thinking about what can be done to help people in our state receive the services that they need. And one of the recommendations and I was a member of this task force, one of the recommendations that came out of the task force was the development of a tier of non-lawyer legal service provider, qualified by education, training, and examination, and a Supreme Court certification, to provide limited legal services to clients. And this had to include representation in court and at administrative proceedings. And so that's where the legal paraprofessional is born. Now, the guiding principles for this concept are obviously, first of all, access to justice, giving more people the ability to afford legal services, including that complete representation, including advocacy in the courtrooms, and especially in the areas where lawyers operate least. Service to the public and economic sustainability, making the certification requirements more focused on those specific areas of law and less costly to obtain than a law degree, so that hopefully those savings can be reflected in lower cost of representation by legal paraprofessionals. We're still in an adjustment period on that, but we hope that as more legal paraprofessionals come into the market, this lower cost fueled by competition will be reflected. And obviously the Supreme Court cannot set rates on what legal paraprofessionals can charge. Professional competence and accountability. We've thought that it was important that there be accountability, and so it was decided that legal paraprofessionals would be affiliate members of the state bar, and that they would be subject to discipline by the state bar, which they are. Um, I I was surprised that there was some pushback on this from some of the attorneys on the task force, but my I think strongest argument in favor of having them as affiliate members was you don't want to be in a courtroom um, advocating in a case against someone who is not subject to the same rules and potential discipline as you. I wouldn't want that. I certainly would not want that. So they are subject to discipline. And so regulation can help prevent abuse also by outside forces that are operating in this unregulated market of self-representation. And respect for our system of justice. The public loses respect for a system that they perceive to be out of their reach and only there for the wealthy. And when the public doesn't believe they can avail themselves of the services of the court, then the alternative is to take justice into their own hands. So in order to continue to do the job that we say and provide the service that we say we are going to provide, it was important that the legal system be accessible to all. I have to mention very briefly that when open for because there were a number, obviously, of rule petitions that had to come, even though this is part of the Arizona Code of Judicial Administration, there were a number of rule petitions that had to be made, changes to the ethical rules, and the bar was not necessarily in favor of this change. And I don't mean the bar, the organization, I mean individual attorneys. I read all of the comments that were posted, and there was a real concern, but when you really drilled down, there was just a concern about the competition that this could potentially engender. But as we get into the different areas where these certifications are issued, I think you will agree that it's an area where there's real need and there are just not enough attorneys. So at any rate, the legal paraprofessional certification is born. It was initially called the Limited License Legal Practitioners. That's the best we could do, or triple LP. The Supreme Court then changed it to legal paraprofessional, and I'm happy about that, because even though the LPs themselves don't love the name, I think it's a lot easier to remember, and there's some sort of comparison we can draw to nurse practitioners and sort of that model. So, you know, you have your NPs and you have your LPs. So it comes then to fruition, as I mentioned, through the Arizona Code of Judicial Administration. If you go to section 7-210, you will see everything that you need to see with regards to LPs certification, what areas of practice, just all the information, how to get certified, the different pathways, which we are going to cover today, but it's all laid out in the Code of Judicial Administration 7-210. There was an early focus on family law as a subject area for the legal paraprofessionals, because this is where the greatest need lies. More than, I think the statistic was more than 95% of cases, or certainly more than 90s, in the 90% of cases, there is, in family, there's one person who is not represented by counsel. In many cases, both. But having operated in that space, having been a trial court judge for close to 9 years and having had my fair share of family law cases, I will tell you, it is harder to have one unrepresented party than it is to have two. When you have two, you can kind of take the reins and guide them both. But when you have one attorney, then it becomes a real imbalance for the unrepresented party. So let's go ahead and get into what is an LP. So an LP is an individual who is licensed pursuant to the Code of Judicial Administration to provide legal services without the supervision of an attorney. That's a really important piece. without the supervision of an attorney in the areas of law and within the scope of practice defined therein. So they must remain within their specific area of certification that determines their scope of practice, and they can practice without the supervision of an attorney, which means they can open their own firm or they can affiliate with an attorney if they wish to do so. And if we read these rules in conjunction with the other modifications that have been made with alternative business structures, now you know that attorneys can pair with non-lawyers in a business. So you could have potentially an LP partner with an attorney in a practice, as long as their practice remains within their scope, as long as the cases they take on are within their scope. So let's go ahead. I'm going to turn it over to Kristy so that she can talk about how does a person become an LP.
Thanks, Judge Cruz. So, spoiler alert, when it comes to the areas of law, there are 5 of them. And we're going to go into each one in a little bit more detail towards the end. But I just want to lay that out for you right now. The licenses that are available are in family law, limited jurisdiction civil, criminal, administrative, and juvenile law. And we will, again, discuss the specific scope of practice within each of those areas as we go on. So our next discussion is just the pathways. How does someone become a legal paraprofessional? The first pathway I want to highlight for you is the experience pathway, because this is the most common pathway so far. And I want you, when you think of experience, I want you to think of your long time practicing paralegal, the person that is the bedrock of your office, who knows more about cases, who has prepared your motions, who does your trial prep. That's the person that is becoming a legal paraprofessional. In fact, I think it represents about 63% of the currently licensed LPs, just to give you an idea of the landscape thus far. The experience requirement is quite large, 7 of the past 10 years, and it needs to be in the area that they're seeking licensure, and it has to be certified by their supervising attorney. Supervising attorney is an important part of that language, because this is not someone who is document preparing. Because if you are an independent paralegal who's licensed as a document preparer, then you're not necessarily being supervised by an attorney. So it does require that certification from an attorney. Then the other pathway is all educational related. And the way I like to phrase this best is that it is degree plus. So there's a specific degree. And as you can tell by the slide, there's all types. There can be an associate's, a BA in law, MLS, LLM, and yes, we do have a few JDs who have become licensed as LPs. So they have that degree, and then they couple it with the required courses. And to give you just an idea of the required courses, they'll ring a bell. It's legal writing and research, evidence, professional responsibility, your practice area specific coursework, and then hands-on learning, which must be supervised by an attorney or a licensed LP in the area they're seeking licensure. You'll notice there's a legal paraprofessional certificate with an asterisk. That is an area that's within the code, but there has not been a standalone certificate program that's been approved by the AJC. So it is an area where we might see some growth educationally in the future, but for now, the pathways that are available are all degree tied. Once the student has either qualified by experience or education, then they must navigate the licensing process. And this is all administered by the Administrative Office of the Courts. And they are the ones that oversee the examinations. There are 2 exams, a minimum of 2 exams. There are 100-question multiple choice tests. The first test is a core exam, and that focuses on ethics, evidence, and legal terminology, and then also ACA just 7-210, just to make sure they're really understanding the scope, and it actually overlays the code with those topics. So a lot of people will compare the test to the MPRE. It's actually quite different from the MPRE just because of these other aspects, but it does at least kind of help you put it in a landscape in terms of what that core test is asking. And then, of course, the practice area exam. Once those exams have been successfully passed, then they apply for licensure. And in that application process is when the background check happens. And this is very similar to character and fitness. Once that's complete, then the AOC staff will make a recommendation to the Board of Non-Lawyer Legal Service Providers. And this board is also the licensing authority for our legal document preparers. They meet every other month. It is a public meeting. If it's something you ever are interested in watching and hearing that process, you are more than welcome to attend. I actually recommend it because it does kind of educate you in terms of what information is pertinent to this process. And once they're approved, then that applicant, just like Judge Cruz mentioned, becomes an affiliate member of the State Bar of Arizona. And what I want to also drive home in that is they pay the exact same bar costs as a licensed attorney. And you also are able to search legal paraprofessionals on the State Bar website. So they are fully integrated into those same resources. After licensure, you'll also probably see some similarities here. Of course, they're subject to the same Supreme Court Rule 42. They have to take the same 15 hours of continuing legal education per year. It just needs to be within their practice area specific to where they're licensed. And they take that same state bar course on professionalism within that first year of licensure. And with that, we're going to segue into our can they do that? So I hand it back to Judge Cruz.
Yes, this is the interactive and fun part of our presentation where you get to be the judge. We'll give you some scenarios and give you an opportunity to think on them, and then we'll discuss the answers. So in the first scenario, a lawyer at a busy law firm is reviewing the mail that has been received for the past week for his cases. He has received a response to a divorce with children, a temporary orders petition, and order to appear, and the notice of appearance. Looking at the caption of the document, he sees the words legal paraprofessional and is thinking, why would an LP file a notice of appearance? Can't they only prepare documents? So that's the question for you. Should a legal paraprofessional file a notice of appearance? And is it true that they can only prepare documents? And maybe this is a good time for us to look at the chat and you can put in your answers on there. See. All right. So mixed answers. Some say you can file a notice of appearance, and we've had a no and no. Okay. Okay. Licensed legal paraprofessionals can prepare documents and help. So legal paraprofessionals can and should file a notice of appearance. They are just like an attorney in their area of practice. So if they are involved in a family case, they should file a notice of appearance, and they can prepare documents. And if they're representing a client, they should prepare the documents, and they can advocate. They provide advice, opinions, and recommendations. They appear before the court, and they can negotiate on behalf of their clients. They can negotiate rights and responsibilities. So think, as long as they are within their scope of practice, think they're just like an attorney. And this, I know, if it's a new concept, for those of you who had not heard of it, it's a little bit difficult to wrap your mind around because we're the only state in the country that's really doing this. Utah has their own model, and I'm not sure where they are now. They were coming out of the box with their own model at about the same time that we were. Washington had a program that sundowned, and in their case, it wasn't necessarily because it was not a good program, but it was too difficult to obtain the certification, too onerous, to the point where you might as well go to law school if you were going to do everything that they wanted you to do for their certification. So let's contrast that with the certified legal document preparer. So we've got the LP that we've been talking about. Let's talk about the document preparer. So the document preparer does complete required education, does pass a legal document preparer exam. They have to fulfill background, moral character, background check. They apply for a licensure by the Board of Non-Legal Service Providers. They're licensed by the Supreme Court. All of those things, just like an LP or an attorney. But here comes the difference. They cannot provide legal advice. A document preparer cannot provide legal advice. They cannot negotiate on behalf of their clients, and they may not appear in court. So remember, that's the key. Those are the key differences between a legal paraprofessional and a document preparer. And of course, for document preparers, they have to adhere to the rules of professional conduct, and they have a lesser requirement in terms of CLE than attorneys and LPs do. All right, let's go with the second one. Kristy?
All right, so this scenario is going to focus on the area of family law. A lawyer has been involved with a divorce involving children that has gotten very complicated. In fact, her client was just served with an order of protection that he wants to contest. The lawyer sends an email to the other party regarding parenting time, since the active order of protection complicates exchanges and communication greatly. The other parent responds that she is represented by an LP and to please direct all communication to that person, and provides the LP's email address. The lawyer has heard of LPs before, but has many questions, such as, and this is the one I want you to chime in on the chat first. Can the lawyer still talk to the other party directly if the other party is represented by an LP? Good, I'm seeing lots of no's. Okay, so yes, that's correct. Once someone is represented by an LP, communications, just like if they were represented by a lawyer, must go through the LP or you are in violation of ethical rules. Okay, our next question. Is the LP able to represent the client at the contested order of protection hearing set for the next week?
Kristy, can I
Yes.
hop on
Yeah,
here just a
of
second
course.
before you go to number 2? This first question and the comment you just made is a perfect example of why it is a good thing that we're having this presentation here. For those of you who are thinking, I'm not hearing anything about LPs in bankruptcy court and in the bankruptcy realm. Why am I here? You're here so that when your client is getting a divorce and the other side has an LP, you don't contact that other party directly, because now you know that the LP is just like an attorney. So that's a perfect point to highlight why it is important that all attorneys in Arizona know about legal paraprofessionals. All right, go ahead.
Okay, order of protection hearing was the question. I'm going to check the chat real quick. And the answer is yes. This one is a little bit more nuanced, simply in that an LP would only be appearing if that order of protection is regarding the same parties and there's an ongoing family law matter, so that it's a related matter to that divorce or paternity action. So it is somewhat limited carve out. It's not all orders of protection in Superior Court. There are other orders of protection that happen that we'll talk about in the civil license for justice court and municipal courts. But when it pertains to family law, those are orders of protection that are issued by Superior Court. And if it is regarding those same two parties, then yes, an LP can assist with that order of protection. The next question is, will the LP be able to participate in negotiations as the case moves forward? And I'm seeing lots of yeses. Yes, this is correct. The LP, just like an attorney, is given the full ability to negotiate on their client's behalf. Now the next one would be, what if there's an appealable issue? And this does happen quite often in ongoing cases or after the judgment's been made. You guys are pros. I should be having you guys teach. Okay, so I'm seeing lots of no's, which is correct. That is a carve out. And I'm going to go ahead and go to the next slide for this last question because it is a little bit more in the weeds. So in this example, the parties had mostly debt to divide, but are there limitations on the types of assets LPs can handle? And the answer is that there are limitations. So just like I talked about at the outset, we have these specific areas of practice. So an LP could be licensed in family law, which just so happens to be the most popular license to date. The vast majority of LPs are licensed in this area. And there are very specific exceptions of what an LP is allowed to handle as far as the case. The first exception being no appeals. The other exceptions include the division or conveyance of commercial property and formal business entities. They also cannot prepare what's called a quadro. If you're not familiar with family law practice, it's a qualified domestic relation order, and it is used to divide retirement assets. They also cannot do adoptions. The reason there are asterisks there is because the way the code is currently written, it says unless the legal paraprofessional has met additional qualifications as established by the Supreme Court. But as of today, right now, those qualifications have not been fleshed out. So those are still things that LPs cannot do as far as a family law case is concerned. So one thing I did want to highlight next too, and kind of it definitely ties into what Judge Cruz's scenario was. You might be thinking, well, if that lawyer hadn't sent that email, how would they ever know that that person was represented by an LP? In the Code of Conduct in ACJA 7-210, legal paraprofessionals are required to identify themselves using the title Arizona Legal Paraprofessional or LP and their bar license number on any document that they prepare. So all you need to do is look at their caption and you will see that it is an LP that is providing the services for the other party. To kind of piggyback on that and drive home the fact that the same regulations apply to an LP. And that first question about, can I talk to the client directly, even though they're licensed by an LP? They fall under the same confidentiality, Rule 1.6, and they also fall under Arizona Rules of Evidence 503, where it explicitly says the same privilege rules apply to communications between a legal paraprofessional and their client. So one further thing that we'll talk about as we get a little bit more into this presentation and as it applies to bankruptcy practice specifically, family law is an area where you will often see a bankruptcy action happening at the same time. So one thing I want to make sure I flag for you early, and we'll repeat it again, LPs cannot be licensed to handle bankruptcy actions. They are not licensed to practice in federal court, and they are not allowed to give advice beyond the scope of their licensure. So if there is a bankruptcy action happening, that LP cannot give advice to their client about the bankruptcy. So that is something that is important to know, that moving forward if you're working with a client in that way.
All right. And I noticed a question earlier in the chat when the first question and the second scenario came up. Can the lawyer still talk to the other party directly? There was a question about which rule would it violate, and that would be Ethical Rule 4.2, communication with person represented by counsel, because LPs are considered counsel. There's a question in the chat also, and I know we were going to take these up at the very end, but as I'm tracking, now we're trying to hit them all. And if we miss something, obviously we can go back, but there's another one. There's no current option for LPs to work on adoption cases. And no, there is not at this time. Why were adoptions not included for LPs? So when we were looking at what areas, this is a decision that was made to see how the LP certification program was going to work. We had to start somewhere. We started in the areas of greatest need, which were family law, smaller civil actions, criminal law, where there is no jail time at risk, either by statute or because the prosecution has decided from the beginning that there will not be jail time. And administrative matters. And then juvenile was added later. There is always the possibility, and there are other areas that are under consideration. I know there's been a lot of discussion about probate coming on. And so potentially, I don't see why adoptions couldn't later become another area, but we just had to start somewhere. So if you think that it would be beneficial for there to be a certification for the area of adoption, that's something you can voice to the Supreme Court. There's a group specifically tasked with monitoring this, and weigh in. if it does start to pick up traction. But essentially, we had to start somewhere, and we wanted to see how it was going to work out. Yes, of course. All right. Now, scenario 3, civil law. A busy civil practice firm has just finished a consult with a lovely couple that got a raw deal with a local contractor. They have a good case, but it's only about $5,000 that they are owed. So the lawyer gave them some forms and told them to file in justice court because it would cost them too much to hire an attorney. So the firm had considered hiring an LP, but the partners were uncertain about the types of cases LPs would be able to handle. So the first question, would the $5,000 case be the type of case that an LP would be able to handle? And remember, this one is in justice court. And I'm seeing the answers. Yes, yes, yes. Yes, it is. All right. So the LP would be able to handle a matter in justice court, but not in small claims courts. So they can represent persons in evictions, protective orders, simple contracts, consumer debt, civil traffic, but the spaces where lawyers are not permitted to practice in limited jurisdiction courts, then an LP would not be able to practice either. And I guess that answers number 2, which was what other types of cases might make sense for an LP licensed in civil law? And I mentioned those. Would an LP be able to work on a case that has more than $10,000 in controversy, but will most likely never see the steps of the courthouse? So it's $10,000, but everybody's pretty sure that they're going to be able to negotiate this thing and not have to go to court. Can that firm have their LP take that case on? I mean, there probably won't be litigation. I steered you wrong. Let's see, someone quoted ER 4.2. Oh. Okay, that's a comment to 4.2. We'll come back to that one. So the answer is no. The LP cannot take on the $10,000 case thinking that it's going to be, that the disposition will be in a certain other way. They have to stay within their scope of practice from the time that they enter the case. All right, and then before I turn it over, let me address the 4.2 comment is, and it cites the rule, and it refers to lawyer. That's correct. It does talk about lawyers, and then there's the suggestion that perhaps we need to revise the rule unless LPs are considered lawyers. LPs are treated as lawyers for purposes of 4.2, even though 4.2 was not amended. But that's a consideration for you. I don't know that there's any petition currently pending to overhaul the ethical rules again.
The ACJA actually addresses this specifically, stating that the rules are to be read for every place that it says lawyer, you are to read as or legal paraprofessional. So ACJA has been kind of the bridge so that this didn't get needlessly mired down in rule, because we would need a committee to change the rules, and then the rules would have to go for public comment, and it would have really stopped this program from being able to move forward in the way it has. So long term, yes, ideally, I think we would go back in and begin the process of updating rules. And I think organically, as those rules come up for revision, that'll probably be something that will happen. But at the outset, it has been a really great way for it to be handled in terms of you should read in legal paraprofessional to the rules that pertain to both the scope of practice, which include the rules of ethics.
Thank you, Kristy. So good catch from Frankie, and thank you for bringing that to our attention, Kristy. All right.
Okay, so let's move forward with our next scenario in criminal law. A busy solo firm has taken on their 5th DUI case of the day. The next appointment will have to be sent elsewhere as there is just no more bandwidth for another DUI client this month. The attorney has thought about hiring an LP to help with the caseload, but can't make heads or tails of the scope. So here's our first question. Can an LP take on a DUI case? What do you guys think? You're correct. Good job. Exactly the risk. There is not a DUI out there that doesn't at least have a day in jail. That's part of the sentencing, or so that is exactly the exception. What kinds of services can an LP provide in criminal matters? And with that, I'm just going to go on to our next slide so you can see the way this was written. I love talking about this area because, interestingly enough, this was the first practice area that was actually modified, and it was modified before we even had anyone licensed in the criminal law area. So when it was first written, it was only written with the top portion, which was the criminal misdemeanor matters that are in municipal or justice court, not subject to a penalty of incarceration upon conviction. And that can be by law or agreement of the prosecuting authority and the trial court. So that was at first all that was authorized within criminal law. And then what was added on was that an LP can do any initial appearance. So now they can be in Superior Court with that addition. When the defendant is not represented by counsel in a subsequent criminal proceeding, they can also still appear for the limited purpose of advocating for release of the defendant from pretrial detention. So there are some very specific carve-outs here. And what's interesting about this is every county kind of approaches this process differently. So we definitely had counties where we had defendants with no representation during this process. So this, again, some of the questions like with family law, why not adoption? Why not? I kind of want to harken back to the history lesson that Judge Cruz gave us, the focus on forming this new legal service provider was access to justice. So we really, the committee was really honing in on where are our biggest needs, where are our biggest gaps in services. So a lot of, if you keep that in mind, a lot of the carve-outs that you see and the practice areas that were selected have to do with that. Where was the biggest need and where can we make the biggest impact in terms of making sure people are able to be represented?
Yes, and there's a comment on the chat, Gideon B. Wainwright. And so I want to remind you, and something that I saw in my county. So when there's an arrest, the person is processed, and then eventually they're going to appear before a judicial officer, and they're going to have counsel appointed. But before that formal appointment of counsel, there's a 24-hour appearance, and where the defendant has the right to request their release. And there is usually not an attorney because the person is just literally fresh off the streets. The public defender's office doesn't even know that they've been arrested. It hasn't even reached the court yet. This is, in our county at least, is done at the jail. And so to have the opportunity to have someone who understands the process go and provide some advocacy, to round up community resources, round up family members, and be able to present that to that judicial officer can be invaluable. So, and then also just to point out, I for a limited time, I remember I appeared in the years ago in our city court, and I learned about the red stamp. I had no clue about the red stamp. The red stamp is the stamp that says the prosecutor is not seeking jail time, and they stamp your file with that, and that means you are free and clear. You're never going to have exposure to time incarcerated, but that also means you don't have the right to an attorney, because if you're not risking incarceration, then there is not the right to have publicly appointed counsel. And we all know that a conviction is a conviction, and it can have consequences in many other realms that go beyond the risk of incarceration. All right.
We did have a quick question in the chat. I know we said we'd save, but it's easier right now.
Yes. No. Thank you. I'm trying to track them, but I told you I'm not 100%.
I'm usually not either, but I was just able to grab this one. Can the public defender's office or attorney general employ LPs?
So there's no prohibition on the government employing LPs. And in fact, this is a development we did not even envision in the task force, but soon after the LP certification became available, some of the smaller jurisdictions, prosecutors' offices, in fact, started asking, can we have LPs representing the state in those criminal proceedings where no jail time is at stake? So that's just a natural development that is permitted, and we did not anticipate. And I think the AG's office was looking at using them in the juvenile realm. Is that right, Kristy?
Yes, yes. And we will touch on that definitely in one of our next scenarios.
All right.
Let's see.
Okay, so the next scenario, number 5, administrative law. A law firm that has largely handled administrative law issues has recently been looking at the areas of bankruptcy and immigration as possible areas, expansion areas for the firm. They take all kinds of cases ranging from education-related issues like disciplinary hearings and IEP issues to representing nurses who are being investigated by their licensing board. An LP recently applied to the paralegal position that was advertised on the PCBA website, and during the interview, they talked about how they would be able to transition to their own caseload in the future. The attorneys weren't sure exactly how this would work. And the question is, what cases can an LP handle if they are licensed in administrative law? Nothing federal is one of the answers. That's correct. What else? What kind of cases is this person certified in administrative law going to be able to handle?
I think we might have stumped him on this one.
Well, the answer is in the question. A person licensed and certified in administrative law can practice in administrative law. They can certainly work for the firm, and all of this other federal activity can be swirling all around them, but they are not going to be working on those cases. They're not going to be heading any of those cases. And the provision says that any Arizona administrative agency that does not preclude practice by legal professionals, that's where they can operate. So this one is a little bit interesting in that the agency determines if LPs can practice. And I think that was a bit of a compromise that was reached. But unless the administrative agency forbids it, then the certified, the legal professional can practice in those administrative areas. They may not represent any party in an appeal, even of that administrative agency's decision, whether it's to the Superior Court, Court of Appeals, or Supreme Court. They can file the notice of appeal for their clients, but that's as far as they can go. And they may not represent any lawyer or legal paraprofessional before the Supreme Court, the presiding disciplinary judge, or any board committee or hearing panel. So in the chat, there's discussion about federal agencies, and that's correct. Remember that this is a state certification, and the state cannot certify people to practice in the federal realm. That would have to come from a federal body. All right. Kristy, you want to take the last scenario?
This is our last practice area. So juvenile law. A contract attorney at the juvenile court is busier than he wants to be, representing parents in dependency matters with the occasional child client. Lately, the hearing schedule has become a bit unmanageable, and the attorney would love to partner with someone. So the first question here is, would an LP be able to help with court coverage? What do you guys think? Low risk here, yes or no? So I'm getting a couple of yes or no's. I think that's kind of what I might have suggested. This one is an interesting area, and it is the newest practice area. And some of you are kind of keen in on there might be some carve-outs here, which is exactly why we asked this specific question. So the short answer is yes, but an LP would be able to cover hearings. And if any of you are familiar with a dependency case, there are multiple hearings. There are review hearings. It's a very long process with a lot of different types of hearings. So what an LP could not do is represent a client that is in a contested dependency or a contested termination adjudication. So those are the carve-outs specific to the juvenile law area. They also cannot assist with ICWA cases. And if ICWA is a new term to you, that's the Indian Child Welfare Act. It has to do with the child's status as a member of the tribes. So those cases are also carved out from something an LP would be able to assist with. And then, of course, the same, no adoptions unless they've met those additional qualifications, which still as yet need to be established by the Supreme Court. This is the one area too and it's the only area that runs into some statutory concerns. So ARS 8-221 establishes the right to counsel for children when it's a dependency matter. So when it comes to child clients, that would be something else that the LP, as of right now, how things currently stand without a statute change, would not want to be engaging in services unless we would risk an appeals situation, possibly where we're running up against a statute that's not reflecting our new landscape of legal service providers. And it's not the first time that we're kind of waiting for laws to catch up with what is happening in society, but that is absolutely kind of the landscape of this newest practice area. And one thing too to kind of flag for both this area and the administrative law area is there are no LPs that have been licensed in these two areas as of yet. So if there's still so much to be learned once we actually have LPs practicing in these areas. And as we've seen already occurring in both criminal and family, small changes are made as we learn from exactly how this plays out in practice. I'm going to check the chat really quick. No, they are not allowed to represent juveniles in delinquency cases. This is a carve out strictly to dependency. And no, there are no juvenile LPs yet.
What was the other area where you said there were two where there were no LPs, juvenile, and what was the other?
And administrative.
Administrative, and such a need in administrative.
And let's see, there was a question that says, I can do guardian ad litem as a non-lawyer, but client, I'm not sure, would be different. Client. One thing that is interesting, it's just like when Judge Cruz was talking about certified legal document preparers. We've got a broad landscape, right? We have a lot of different little niche carve-outs that are happening in our world to try to make to try to meet this access to justice gap. So it's going to be ever more important to stay on top of who can do what. So this training, we're striving to help you understand and get a better idea of what an LP is allowed to do. And it will change as things move forward. They're already exploring 2 new areas for 2025. Preparation of the quadro for family law cases. So the qualified domestic relation order for retirement is an area they're looking at. And probate is another area that's under consideration. So this will be something that will continue to evolve, and I encourage you to stay on top of and attend future trainings just so you are aware of how it is growing and changing. Many of you might be familiar with immigration, and there are carve-outs already in immigration for non-lawyers to be able to assist with FOIA requests and some of the green card requests that happen more on a administrative level than the actual immigration court proceedings. So it is one of those things where there are carve-outs that exist in other ways, but those are not under the LP licensure. And that's what I really try to drive home with people. There are very specific abilities allocated to an LP that are different and separate from these other carve-outs.
There are a couple of questions in the chat that I want to address before we wrap up. One is, should we let LPs represent our most vulnerable? I could see a future SCOTUS challenge on this issue. And I think it's important to remember that these areas of certification are areas where studies have shown that there are hardly any lawyers practicing. So when you're talking about that person who is facing their 24-hour appearance before a judicial officer, and they don't have a right to have immediately until they go to court for appointment of counsel, they don't have the right to have an attorney. So what we're saying is that they should go alone. In family cases, people do not have the right to court-appointed counsel. So if we don't have a certification such as this one, then people are going to court alone. In small matters, civil matters in limited jurisdiction court. So when you look at those areas, the alternative is zero. It's not between an attorney and an LP. It's between LP and nothing. And when you look at what we've gone through, how a person becomes an LP, we see that we're not talking about minimal qualifications. There was a high failure rate when the test first was announced. And why was that? Because some people mistakenly thought this is a backdoor into practicing law that'll be an easy way to get in the courtroom as an advocate. And that's not what this is. They have to be proficient, just like an attorney, but in that one specific area. There's also a question, if an attorney has an LP in their practice, is that attorney liable for the LP's own practice? No, the attorney is not the supervisor of the LP. I suppose there could be some liability if there was some work in concert, but it would be just as if you were partnered up with another attorney. There are limits to what responsibility you have. If you were not involved in that representation, then that attorney is responsible for what they've done in that case. Same thing with the legal paraprofessional. The legal paraprofessional is not practicing under the attorney's license. Let's see, since there's no pricing restriction, what is to prevent LP from charging the same as counsel? Nothing. An LP can ask for the same rate, but will people pay? What is the incentive to pay an LP the same as you would pay an attorney? I suppose the only incentive to do that would be if you know of their reputation and they are very, very good. Maybe you might decide, I know how this person works. I've seen their results, and I have to have them. And so if they're a standout, I suspect they can command a higher rate. But the court cannot regulate the rates that attorneys or LPs are charging. Thank you for the question. But yes, the goal is that with inserting these additional folks into the market, that there will be affordability. These are very good questions. Thank you. I see that we're at 12:59. That if LPs, yeah, some LPs are charging a high rate, and when I have recommended. I've recommended to people to look for an LP because they are of limited means. And when that has happened and they come back and tell me, well, they're charging, X amount of dollars per hour, I tell them, well, then why would you want to hire them? Go hire an attorney who's going to charge you the same or less. So
this really will be a market correcting thing. You have to remember we have, I think, like 70 in the 70s number of licensed LPs in the entire state right now. So, and many of them are working for attorneys. There aren't that many who have started their own firm. There's maybe 10 of those who are running their own firm. So if you only have 10, we're not really creating that market competition yet. So as there's more LPs, you will see this level out because they won't hire an LP if they're charging as much as an attorney. It's the same. I mean, if a Ford was priced the same as a BMW, I might make a different choice. So it would be kind of the same thing in terms of that. And especially if it's someone who is going to need help in multiple areas. Because remember, an LP is only licensed in their area. So if you've got multiple issues going on, then that might not be the best fit. So that's the other thing to remember too.
But like I said, I mean, if you think about it, in some cases, why would you want to hire an attorney who is someone who can practice in every area? And some attorneys do practice and they'll take anything that comes through the door. Would you hire that person as opposed to an LP who is focused solely on family and has produced excellent results? You know, that's where you have to decide. We are out of time. I do want to answer one question very quickly. Is there a requirement for malpractice insurance? No, there is not, just as there is not for lawyers in Arizona.
There is an insurance company who has stepped into that void, though, just so you're aware. Ahern, which you've seen advertised on our own state bar for attorneys, has worked and paired to make sure that there is affordable insurance for LPs. Because remember, if an LP is going to be able to provide affordable rates, they have to be able to practice at an affordable rate as well. So it's been really useful. So just so you know, there is affordable malpractice insurance available for LPs.
Thank you so much for your time. I see it's 1:02, so we have to wrap up. We appreciate you allowing us to come into the space and share with you a little bit about the LP certification. If you have any questions, please reach out to us. I hope we've answered them and that you are ready to go out there and recommend LPs to your clients as their needs may so require. So thank you so much.
Thank you, Judge Cruz and Professor Clairmont. Thank you so much for coming and presenting for us. I know I've seen a lot of the comments in the chat about how helpful this has been, so we are all very grateful to you. To the rest of you, the CLE certificate is placed in the chat box. As I said earlier, grab it now, or you may never get it. It's been put there twice as a PDF file. Again, if you can't see it, please let us know. Otherwise, please just download it before you leave. Be sure that .pdf is included at the end of that attachment when you save it. Thank you again, ladies. Appreciate you very much.
Yeah, if Frankie asks about the materials, if you can't download them from here, just email admin@acbcforum.org and I'll be more than happy to send them to you. Again, same with the CLE certificate. This has been recorded. This will be available at the ACBC website under the non-member area. Give me the weekend to get it up. All right, and please feel free to share it with others. And please, thank you very much to our faculty. This was an excellent program.
Thank you.
Thank you.
Thank you.
Bye, everybody.